accepted. In fact, it's even part of our rules of court right now.
It's standard for construction companies to go into arbitration.
To go arbitration, yes.
Because otherwise, that road is not going to get built, right? So,
Yes.
and when with trademarks, it's business, and time is of the essence. So that's why parties have to go to which body, the IPO or the arbitration?
They go to the IPO. They can go, for example, to us if they want, number one, a concern on writing their arbitration clause or entering into an arbitration agreement. If there is a case filed before the IPO, the system right now is they go through mandatory mediation. And when the case is not settled through mediation, they go back to the originating office. And the originating offices would tell them if they want to go to arbitration or choose the regular route. If, for example, they chose arbitration, I come into the picture, I explain to them the procedure, and then we prepare the arbitration agreement, they sign the contract, and we refer the contract to the Philippine Dispute Resolution Center.
For scrutiny?
For referral.
For referral.
And we help them in the appointment of the arbitrator. You go through the hearing, if they choose a hearing, and once there's a decision, it goes back to the IPO for scrutiny. And after the scrutiny, we bring it back to the arbitrators, and they will release it officially to the party.
You said if they choose a hearing, so it's possible that if we, for example, pull out from the IPO a case and then decide to go into arbitration, it's possible that the parties will agree, let's not go through a hearing?
Yes, it is possible. Like, for example, if they just want to submit their positions, the parties can choose to do that. A very good example, for example, of arbitration is when have you seen a Social Network movie?
Yes, the movie. Yes, Mark Zuckerberg was under trial, and it was a very, more or less an informal setting compared to
Yes. It doesn't look like a court procedure, right? They're just inside
a classroom, I think.
Classroom or maybe a law firm or something like that, and someone is taping the deposition or something. It could be, it's very similar to arbitration.
So that's how arbitration proceedings
more or less
happen.
Yes.
More or less. Yes. But for example, you said that once an arbitral award is executed, it cannot be appealed. So the parties have to comply, have to enforce that. They have to abide by it. Because more or less, an arbitral award is more like a contract.
Award is more like a decision of the court.
It's more like a decision of the court.
A result of your contract, because you have agreed for a panel to decide on your case. Yes. And then when they issue an award, it can be enforced in the regular courts, like a regular decision.
But when can arbitral awards not be enforced? I mean, is that even possible for?
Well, it rarely happens in my experience, but sometimes it is used as a delaying tactic by some of the lawyers. You know how the legal system works in the Philippines.
But what if, for example, the thing in question or the thing in litigation or the object of litigation is, for example, cure for cancer. I discovered a cure for cancer. I don't want anyone to be to hold the license over that, which means I want to have a monopoly over that drug, right? So I can jack up the prices, make it very expensive for people to avail of that particular medicine, and then someone sues me in order to, for example, license my invention to the government. Just a hypothetical example. And then we decide to go into arbitration instead of the usual court proceeding in order to speed up the case. And during arbitration, the arbitrator rules in my favor that I have patent over my invention. The government cannot license it out of me, or they cannot force me to license it to them, rather. Will that, for example, decision
be enforceable? Well, Sara, this is a public policy issue, and we really don't know if it's going to be enforceable. But I would say, for example, here, my personal opinion is that it involves public policy. And we have the scrutiny provision in our rules tries to avoid a situation wherein you can issue, or wherein the arbitral award will be unenforceable because of public policy issues. Let's say, for example, this is a strong public policy and the country will never allow something like that, and it will never be enforced in the court. We will, in the IPO scrutiny desk, tell the arbitrator that, hey, your decision is not enforceable because it is a public policy issue against public policy, and that maybe you should reconsider that. But as I had mentioned to you, this is not an appeal procedure. We can only recommend what we think is right to the arbitral tribunal or to the arbitrator if it's a sole arbitrator. And most of the time, more often than not, well, they wouldn't dare go against the recommendation of the experts.
Yeah. and well, those experts which are chosen by the parties are also, well, their professional fees are also paid for by the parties.
Yes. Like if you're referring to the arbitrators,
yes, the arbitrators, the judges. Because I really think of them as judges, and I'm very glad that we are now offering arbitration. As you said earlier, it's not common in Asia, in the region, to have countries with arbitration capacities, particularly in intellectual property.
Intellectual property, yes.
Yeah, so you need to build up the capacity, you need to certify that you can...
You can do it.
You can do it,
You have the experts to support you.
You have the experts, you have a pool of experts that they can choose from. They can make it into a jury with 12...
Yes, if they want to.
12-member panel or just one arbitrator. I mean, everything's flexible depending on the parties.
On the parties, yes.
Yes, but usually, which countries in Asia have arbitration capacities in terms of intellectual property? I mean, are all countries
Singapore is
doing
Singapore is doing very well. In fact, WIPO introduced an arbitration and mediation center in Singapore. And, well, they're doing very well. Hong Kong is another jurisdiction doing the same thing. If you go to China, they're also introducing arbitration because, you know, IP is already becoming a very big factor in developing their economy.
In China.
Well, yes, yes, of course.
So they also have arbitration. Or
yes.
They are more or less building up their arbitration.
They're building it up right now. Like, well, the major institutions around the world, major arbitration centers around the world, they have a China desk because it's a big market. Like, personally, I know that they have a China desk in the Singapore International Arbitration Center. The same, I think also in London, they have a China desk.
They have a China desk. Okay, so the Philippines is starting up. And this is a new office in the IPO. How long have you been existing?
Yes, the research started about 2 years ago. It was started by Attorney Boy Panga of ADB and a major IP law firm in the Philippines. And it started to materialize early last year. We hired someone to do the mediation, and I was hired to do arbitration.
To head the
yes,
arbitration
and then
office.
we designed the rules over the last year, and we trained the arbitrators also last year, and we're ready to do the launching on the first quarter.
First quarter. So within the next month.
Within the next month.
Next month, yeah. So they're going to launch it. They're going to open this to the public as an option to resolve their disputes.
Exactly. Yes,
Yeah.
yes.
How come you are very passionate about arbitration? I mean, may I ask?
I did my graduate studies in arbitration, my first one, and
your first master's in law. I mean, as I wrote, studying law, you went on to take your master's on arbitration.
On arbitration and intellectual property. And
Where's this?
my professor was actually the one who designed the arbitration system in Thailand, and he was the one who helped Australia also put up their arbitration office. And they were discussing to me the possibility of designing a specialized arbitration for construction cases, intellectual property cases, or family law cases. And I was thinking as early on that maybe it will be a good fit if we will have an arbitration in intellectual property. And lo and behold, there's this WIPO AMC who's very successful right now. Yes.
Yes, and they also trained you. I mean, you also...
I'm in close contact with some of the officers of the WIPO AMC. And yes, we've been in touch, we've been discussing issues here in the Philippines, and they've been very helpful.
And you're confident, of course, that the pending cases, or at least whatever pending cases there are in the Intellectual Property Office of the Philippines, might choose to
go arbitration.
Go the way of arbitration.
Yes, we're very confident. Number one, because I would say, maybe it's okay to say this, that the big or the major law firms in the Philippines are supporting this initiative. We have big names from the litigation department, from the IP department, the LES and the IPOP, and those organizations of IP lawyers are pushing this because they are aware of arbitration. A few weeks ago, I had a meeting with a senior executive in a multinational company, and she was saying that it's about time that we develop an arbitration system in the Philippines, because when they design a contract, they always recommend Singapore or Hong Kong, and because
those are the only places that offer arbitration. Yes, those are the only options.
And if they had a choice, they would put the Philippines there if only we had a mechanism to support the system.
So this is good news for all business owners, multinational corporations, and of course even the sole proprietor businessmen and women we have in the country.
Agree.
So if they want to speed up dispute resolution, they can go by way of arbitration. Only they have to go to the Intellectual Property Office of the Philippines in order to avail of this mechanism.
Avail the mechanism.
And pay the
corresponding fee.
The corresponding fee. But it's minimal compared to going into court. And well, of course, we want to help out our judges.
Yes, that's true.
I mean, they're already settled with criminal and civil cases.
Civil cases, yes.
And then, as you said, intellectual property is very technical. What if the litigation is over a drug, right? And you're talking toxins and whatever the elements there are in it. right? So you need people with background in order to resolve or hear out
the case. Yes.
the case.
Exactly. Like me, Sarah, I've been doing IP for like 6-7 years right now,
Wow.
and I will never profess to be an expert in patent. Although I've read how to do it, like application process, and then reviewed some patent documents, I will never attempt to sit in an arbitration involving a patent case. Because it is highly specialized.
Yes, and highly technical.
Yes, and even in patent, you have to be very specialized on specific areas. Like
yes,
if you chemistry,
yes,
physics, or something.
Yes,
right?
what if it's a machine in dispute that you copied my
exactly.
mechanical
Yes.
engineering process here or something? So you really need someone with a background. And that arbitrator does not necessarily have to be a lawyer.
A lawyer, yes. He could be an engineer if your problem is about, machines and everything. He could be a chemist if it's about chemistry. He could be anybody.
He could be anybody that you've chosen and accredited.
And accredited by the IPO.
And although there are exceptional cases wherein they are not accredited, but since the parties want to choose them, you leave that to the parties because it's still a private effort.
It is a private setup.
It's a
it is
private
contractual.
Setup.
Yes, as long as the parties have agreed, they can tweak the rules, they can adjust some provisions according to how they want to see it or how they want to go through the process.
Yes, and they can, as you said, they can shorten or lengthen the hearing
yes.
dates. They can choose. Can they choose to have hearing outside of the Philippines?
Yes, they can do that.
Even if the jurisdiction is really...
Well, actually, it's
going
to be very impractical. It's going to be very impractical. But they can provide in the rules that we're going to use the Philippine, the IPO PDRC arbitration rules, but the venue or we're going to conduct the hearing should be in Hong Kong or China. But I would suggest better choose Boracay or Cebu.
Yes, let's have a hearing in Boracay and let's bring our lawyers there.
Yes, lawyers will be very happy.
Yes, and come to think of it, for example, in trademarks, which is something that we both specialize in, there are many licensors or licensees, and their usual problem is trademark cancellation. Someone registered an internationally well-known trademark ahead of them due to the first-to-file system. And it's hard to bring in CEOs of multinationals into the country in order to, for example, to attest that he or she is the CEO, that this corporation exists and based in this and that country. So, to provide the venue here, for example, will be very convenient for anyone
for
doing
the parties.
Yes, for the parties.
And another thing, of course, you want to be represented by someone you trust. In the arbitration, there's a provision which would allow a foreign practitioner to represent the client from another country. Although, of course, it is subject to the rules of court on, appearing before an arbitration tribunal. You cannot appear in any other venue or forum other than that case, specific to that case.
So we're providing that exception.
Yes, we're providing that exception.
Yes, for everyone's information, no one can practice law except Filipinos in the Philippines.
Yeah, we're very strict with that.
Yes, we're very strict with that. We don't allow other citizens to become licensed practitioners of law. But during arbitration, they can have limited appearance exclusively for that case.
For that case,
like the arbitration.
Or like for example, you're not really aware of what is happening. You want to send your lawyer from another country here in the Philippines. You just check out on what is happening. Our rules here are very restricted to that. But in the arbitration, the foreign lawyer can appear to the office, make an inquiry, make the preliminary procedure, sign the preliminary documents, and ready all the things that are necessary before you appoint a local practitioner.
Okay, so you can do all that background check.
Yes.
And again, just a point of clarification: the salaries of the arbitrators will come from agreed upon by the parties. Well, so there's no point in trying to corrupt your arbitrator because you're going to pay for his or her salary.
Yes,
anyway.
The schedule of fees is based on the design of the PDRCI, and it is primarily based on the amount involved. Yeah. So, for example, if you have a 100 million case, the fees will depend on that. But if you, for example, have a minimal amount like 5 million, 3 million, it would not be as much.
Okay, so everything depends on the amount involved.
Like the way they do it in the construction industry.
The way they do it in the construction. Again, Attorney Lope Manuel, thank you for gracing our show and talking to us about arbitration. Good luck on the launch of the Arbitration Office next month. So, ladies and gentlemen, there you have it, another edition of Intellectual Property. Again, we'd like to thank the World Intellectual Property Organization and the Philippine Intellectual Property Office for bringing this show to GNN. We'd like to thank as well David Salon for my hair and makeup. Okay, tune in again next Friday for another edition of Intellectual Property.
Everything we listen to, everything we watch, everything we read, everything we wear. behind all our favorite things, there is an author, an artist, an inventor. Genuine, real, original. Pushing the limits of imagination and innovation for our comfort, our enjoyment, making life interesting.